Good morning, everyone. Thank you for joining us today. My name is Daryl Supersad, and I'm here today with my colleagues Allison Lee, Luisa Viknovich, and Mike Sherritt. We have roughly 2,400 people registered for today's webinar, which perhaps reinforces the importance of today's topic, workplace health and safety. The format for this morning is as follows. We will present from 9 a.m. to roughly 10 a.m. and then answer questions until roughly 10:30 a.m. If you have a question, please type it in the chat box on your screen. Sorry, please type it in the Q&A box on your screen. Do not use the chat box as it should be disabled. Again, that is the Q&A box and not the chat box. We'll do our best to answer all questions that we receive, but if we don't get to your question, please feel free to reach out after the presentation. Finally, a recording of this presentation and the slide deck will be on the homepage of our website within a day or two. So without further ado, let's get started. So turning to today's agenda, Allison and myself will be covering the workplace safety and insurance update. We'll be discussing the WSIB's recent changes to rates and benefits, amendments to the WSIB accident reporting process, the WSIB's new policy on communicable diseases, update on the chronic mental stress claims, practice tips to manage claims and reduce liability. My colleagues, Louisa and Mike, will be discussing the health and safety portion of today's presentation. They will focus on recent trends in charges and fines, with a special focus on critical injury trends, Ministry of Labor blitzes, and enforcement trends. They'll also discuss the difference between inspection and investigation, the impact of R and Sudbury on construction site owners, and due diligence practical tips to minimize risks. Turning to today's agenda, we'll start with the workplace safety and insurance update. An issue that has been in the news recently is the WSIB's practice of indexing workers' benefits. The WSIB increases wage loss benefits for workers that have entitlement to wage loss benefits from one calendar year to the next, meaning for those workers that are entitled to receive wage loss benefits in December of one year and continue to receive benefits in January of the next year and beyond, they will be eligible to have those benefits increased. The theory behind these increases is to ensure that WSIB benefits keep pace with the cost of living and the rate of inflation. In 2023, that increase was 6.5%, and in 2024, that increase was 4.4%. Now, there has been some concern in the employer community about the rate of these increases, as typically these increases are indexed to the consumer price index. Now, the concern with regards to these increases comes from the fact that 135,000 workers are eligible to receive index benefits. However, the WSIB in October 2023 has confirmed that the average premium rate for employers will remain unchanged going into this year, 2024. That average rate is $1.30 per $100 of insurable earnings. In fact, since 2018, employers have seen an overall reduction of their premiums to the tune of $8.5 billion. However, the Ontario government has recently proposed legislation that, if passed, may increase premiums by changing the indexing formula used by the WSIB. The proposed Bill 149, the Working for Workers for Act 2023, will allow the government to add an additional indexing factor to the cost of living adjustment beyond the rate of inflation, thus adding a super index to the cost of living adjustment. Currently, this bill is at standing committee, and as it's currently written, does not provide much in the way of details of how or when the super index will apply. However, if this bill is passed, employers are encouraged to review their claims to determine which claims would be liable for super indexing. And remember, those are claims that are typically of longer duration, where wage loss benefits are paid from one calendar year to the next. And once those claims are identified, employers can consider managing their claims by either returning injured workers to suitable modified work, if possible, thus reducing the amount of wage loss benefits that those workers would be able to receive and thus subject to super indexing, or challenging the issuance of those wage loss benefits where applicable. Now, in other news, the WSIB has added 3 new occupational diseases to its list of occupational diseases at Schedule 3 of the Workplace Safety Insurance Act. These diseases are poisoning due to work-related exposure to ammonia, poisoning due to work-related exposure to chlorine, and poisoning due to work-related exposure to hydrogen sulfide. Now, having these diseases listed in Schedule 3 of the Workplace Safety Insurance Act means that a worker, in order to receive benefits, must show that they have been diagnosed with one of the listed diseases and that they were working in an environment where they had exposure to either ammonia, chlorine, or hydrogen sulfide. Once the worker provides those two pieces of evidence, the WSIB will presume that the worker's illness is work-related and issue benefits. An employer can rebut this presumption by demonstrating that the worker was not exposed to ammonia, chlorine, or hydrogen sulfide at the workplace, or that the employee's illness had a non-work related cause. Now I'll turn it over to my colleague Allison so she could discuss the next.
Thanks, Daryl, and good morning, everyone. It might seem like a minor administrative change, but for me, one of the more important things that happened in 2023 was this change, which is that effective September 29th, 2023, an employer has 3 days, 3 business days, to file the accident report, which we all know and love as Form 7, after it learns of its reporting obligations. This is important because earlier WSIB policy had said that the Form 7 has to be filed within 7 business days. Now, remember that a Form 7 is required when there has been a work-related accident and the employee has required healthcare, and or the employee is absent from regular work, the employee earns less than regular pay for regular work, the employee requires modified work at less than regular pay, or the employee requires modified work at regular pay for more than 7 calendar days after the date of accident. Now, you might be sitting there thinking, but Allison, hasn't the Workplace Safety and Insurance Act always required a reporting within 3 days? And you are absolutely and totally correct. Section 21 sub 1 of the WSIA has always said you require the report within 3 days. But what a lot of you will know, and what a lot of your frontline supervisors and managers will know, is that the WSIB policy has always provided a 7-day grace period. And the reason for this was quite frankly, the mail. Maybe you stuck it in the mail and it got a little delayed getting to the WSIB, so you had 7 days to get it in. What's happened, though, is the WSIB has realized that we're all filing them electronically these days, and therefore the grace period is gone. So that's something to remember. That grace period that used to exist no longer exists. This is important to note because there are penalties for late filing. So if you late file your Form 7, you're going to be charged a penalty of $250. It can go up to $1,000 if it's filed more than 30 days after the obligation to report. It's going to be rare, but in certain cases, it could also result in prosecution as an offense under the WSIA. So please file your Form 7s in a timely manner and remind everyone it is 3 days, no more grace period. One of the other interesting things that happened in late 2023 was the WSIB's new communicable illness policy. This took effect December 1st, 2023. And it's interesting because this is the entitlement guide for when a worker who has a communicable illness arising out of or in the course of employment is entitled to workplace safety insurance benefits. The first question we all ask is, okay, what's a communicable illness? The definition the WSIB provides is that it's an illness resulting from infectious agents such as viruses, bacteria, and fungi. So immediately we all think, okay, influenza, COVID-19, norovirus, that sort of thing. You would be right. But communicable illness doesn't just mean an illness that's communicated from person to person. It could also include different communication or transmission routes. So this might include animal to person interactions, so something of that sort. It could be ingesting contaminated food or water. It could be contact with contaminated surfaces or objects, or may include exposure to infected soil or environmental sources. So sometimes we forget about those bacteria and fungi and contamination type ones, but those would also be communicable illnesses under the WSIB's policy. There is a two-part test for determining whether or not a worker has an entitlement under the communicable illness policy. The first branch is, has the worker contracted a communicable illness? And the second branch is, was the worker's communicable illness arising out of and in the course of employment, which will be a familiar phrase for a lot of you who deal with WSIB. And this really means, did the employment significantly contribute to contracting the communicable illness? So to go to that first branch of the test, how does the worker establish that they contracted a communicable illness? The WSIB is going to generally require, one, a positive result from a laboratory or diagnostic test, and or the second thing, which is diagnosis by a treating health professional who is qualified to provide such a diagnosis based on the clinical assessment by that health professional of the worker during the period of illness. The fascinating thing here, I think, is that and or. So sometimes the WSIB is only going to require one or the other. It's going to depend on the illness and the diagnostic criteria for that illness. What's even more interesting, I think, is that certain situations, the WSIB is not going to require either of these. Because of the wide range of communicable illnesses, the WSIB may find that a worker contracted a communicable illness and met that first branch of the test based on evidence such as a serology test that shows that there was a past infection, or maybe results of a Health Canada approved point of care test that shows a current infection, as long as that point of care test is in line with Health Canada guidelines. In certain very unfortunate circumstances, it's going to be a report from a coroner, so indicating that the cause of death or a contributing factor to the death was a communicable illness, and that would also meet this test. Lastly, the WSIB has said that in certain circumstances, the fact that the worker's signs and symptoms align with a communicable illness, and the communicable illness is known to be prevalent in the employment setting, and considering the worker's history of possible exposures, would mean that the worker can meet the test. That's a really confusing one, and the example I would use there is norovirus. So let's say you've got a workplace outbreak of norovirus, and you have an employee who's showing the signs and symptoms of norovirus. The WSIB in that situation may not require a positive test from a laboratory or a diagnostic test, nor may they require a diagnosis as long as the worker is showing those signs and symptoms consistent with norovirus. The WSIB has also recognized that in certain situations, there are going to be valid reasons that a worker can't have gotten medical attention properly and might have delayed seeking medical attention. And the WSIB has said already that such delays in certain circumstances are not going to take away from the worker's ability to prove that they contracted a communicable illness. So this can include things like the worker not qualifying for or not being able to access laboratory or diagnostic testing, or if the worker was following guidance of public health and, for example, quarantining or otherwise isolating. So you can see that the WCB is taking some lessons from the COVID-19 pandemic about situations that might occur that require flexibility in this element of the test. That brings us to the second branch of the test. So if your workers established that they contracted a communicable illness, the second question is going to be, did the illness arise out of or in the course of employment? And you'll see another one of these lovely and/ors here. The WSIB is going to generally require an established work-related source. So something that could be an established work-related source is, if there's hoof and mouth disease going around, it would be that there are animals with hoof and mouth disease at the employment site, and or increased risk due to employment. This is a bit complicated. And the reason it's a bit complicated is because although not all communicable diseases are widespread, some of them, like COVID-19 or like influenza, are going to be prevalent in a community, and individuals might encounter multiple possible sources of infection. So let's say influenza or COVID-19, you've got an outbreak at the workplace, but the workers also have their kids in school or daycare, and they go grocery shopping, encounter a lot of people when they're out and about. Those are all possible routes for that individual to have gotten the communicable illness. So what the WSIB is going to do is they're going to weigh all the relevant evidence, not illness, including the medical records of the worker and the evidence of employment and non-employment context to look at what are the possible sources of infection for this worker. The decision maker ultimately has to be satisfied that it is most probably work-related. Now, you'll recall on the last slide, we had said you either have to establish a work-related source or increased risk due to employment. And so what we've put up here are a bunch, What we've put up here are a bunch of increased risk factors that are going to say to the WSIB, okay, here are some factors that make it seem it's more likely the communicable illness is arising out of and in the course of employment. So if your rate of illness is higher in the employment setting than in the general population, and that would generally be an outbreak situation. Secondly, let's say the employment activities create opportunities for exposure and transmission that exceeds the opportunities in typical day-to-day activities. So you might have evidence of a worker who doesn't actually go out very much or see a lot of other people, but has a customer-facing job, and they have to go into, let's say, old age homes, or they have to go into people's homes, and it's known that that old age home had a COVID-19 outbreak. Thirdly, if you have activities that require contact with animals that carry illnesses, that's obviously an increased risk factor. Activities that require handling or contact with materials susceptible to fungal contamination is going to be a big one. Same as activities that require a worker to have contact with infectious substances or contaminated objects or surfaces. The other one that's rather interesting is when a worker is required to stay in employer-provided accommodations, and there is one or more persons in those accommodations that's known to have or suspected of having the illness, that's also going to be an increased risk factor, and therefore lean towards the communicable illness being work-related. Other relevant factors when evaluating work-relatedness include as follows, and you might be saying, wow, there's a lot of factors here. And it's because, as I said, the policy is structured right now to take all the context into account and have the WSIB weigh all these factors to determine if the communicable illness that's contracted really is work-related. So first one, potential exposure outside of employment. We've discussed that. That's, the worker's kid is at the daycare that has the outbreak. Well, that's a pretty big exposure outside of employment. Mode of transmission is going to be, is it a droplet transmission? Is it airborne? Does it require person-to-person contact? And how does that change how likely it was that they got the communicable illness at work? The duration, frequency, and intensity of potential exposure is all going to be taken into account, right? How long did you have to spend in that nursing home that had the COVID-19 outbreak? Workplace control measures is an interesting one because that's one of the ones that we as employers have some control over. So we're talking things like PPE, okay? We're also talking about what are your infection control measures if there is an outbreak. And I'm going to reiterate this a second time later on because it's so important. You really want to be thinking about your workplace control measures so that you can show, the WSIB or anyone else who inquires that you took reasonable steps and the odds of the communicable disease having come from inside the workplace are lower than they otherwise would have been. Compatibility with incubation period is another relevant factor. And what that means is from the time when the alleged exposure or accident happened to the time when the worker started having symptoms, was that within the incubation period of the illness? If it is, that leans towards that exposure having been the one that actually communicated the illness to the worker. It's interesting to note, of course, that the WSIB has specifically recognized that influenza and COVID-19 are easily transmitted and widespread in the community. And the WSIB has therefore said that if the only evidence put forward by the worker is that they had frequent in-person interactions at work with customers or coworkers, that alone is too speculative to establish work-relatedness. There has to be something more, okay? A little bit more evidence that makes it probable, not just possible, that the worker got the communicable illness from work. Now, let's say both branches of the test are met by the worker. When the claim for communicable illness is allowed, the worker is going to be entitled to benefits for the period of communicability of the illness, even if the worker is asymptomatic, if that communicability prevents ability to return to work. So what does the WSIB mean by that? What they're really saying is that if that individual is basically infectious or could otherwise still communicate the illness, and they have to stay out of work because of it, even if they're asymptomatic, they get benefits because they're being kept out of work due to the communicable illness. Interestingly, however, If the worker is required to self-isolate or sent home because of exposure, but doesn't have any symptoms or a positive test or diagnosis, they are not entitled to benefits. So if you've got an outbreak and you send home, employee Bob because he's been exposed, but he doesn't have any symptoms and no positive test, no benefits for employee Bob from the WSIB. One of the really, and I think I've said this like 3 times, but it's a really interesting policy. One of the really interesting parts is that benefits are not going to be denied to a worker solely because the worker has chosen not to get immunizations or vaccines against the communicable illness. If there's a claim for benefits, the fact that that worker made that choice not to get vaccinated or not to get immunized doesn't actually deny them benefits from the WSIB. And with that, I'm going to turn it over to my colleague Daryl to talk about mental health.
Thank you, Allison. All this talk about communicable disease makes me happy we're in separate rooms. But to turn to the chronic mental stress policy, just a quick recap for those that may not be familiar with this policy. A worker can gain entitlement to WSIB benefits for a psychological condition if that worker can prove that that psychological condition was appropriately diagnosed, meaning by a health professional, and the condition is listed as one of the psychological disorders in the DSM diagnostic manual used for psychological disorders, and that the worker experienced a substantial work-related stressor, and that stressor was the predominant cause of the worker's diagnosed psychological injury. So the predominant cause meaning that it was either the sole cause of the diagnosed injury or the main cause of the diagnosed injury. Typically, the WSIB would view workplace harassment or bullying as substantial workplace stressors. They would also view jobs with a high level of routine stress as a substantial workplace stressor. Think jobs such as children's aid worker, that sort of thing, where you're routinely exposed to very stressful and emotionally charged situations. But interestingly, the policy does not provide for benefits for those that have stress injuries related to the action or decision of an employer related to employment, such as discipline or termination. The WSIB views these stressors as inherent in the employment relationship. To date, the vast majority of chronic mental stress claims have been denied. I think the current rate is around 90% versus 25% for all other claims. 2021 Ontario Divisional Court decision confirmed that the ability to claim a chronic mental stress injury at the WSIB will not bar a constructive dismissal claim based on the same conduct. So as you may know, if the WSIB recognizes a worker's injury as compensable under the Act, that worker cannot then go and sue their employer in court for damages flowing from that injury. In the 2021 Ontario Divisional Court decision of Morningstar and the Workplace Safety Insurance Appeals Tribunal, the court decided that if a worker had a claim for a constructive dismissal arising out from the same fact scenario as the psychological injury, in that case it was workplace harassment, then the constructive dismissal claim could proceed against the employer, whereas the claim for damages related to the psychological injury could not, as they are two separate claims. Recently, the Workplace Safety Insurance Appeals Tribunal, and that's the tribunal that oversees the WSIB, reviewed the chronic mental stress policy in their decision of 69320. In that decision, the vice chair discussed the predominant cause test as it relates to chronic mental stress injuries. And he opined that this test was too restrictive when compared to the WSIB's test regarding the test for causation for physical injuries, the significant contributing factor test. The current chair of the Workplace Safety Insurance Appeals Tribunal reviewed this decision, and while she did say the hearing vice chair did not need to decide the issue of the predominant cause test to complete that case, she did say that the issues raised about whether or not the predominant cause test was an appropriate test to be using for psychological chronic mental stress injuries was a substantial issue that would benefit from investigation by the Workplace Safety Insurance Appeals Tribunal. Bearing this in mind, we are keeping a close eye on this area of law as it is a bit unsettled, and we will inform you if there has been any changes to the WSIB's chronic mental stress policy as a result of the WSIAT's interventions. Now, turning to practical tips. So, in relation to the super indexing issue, we discussed a little bit about how employers should identify and closely manage claims that can be subject to super indexing. Again, those are claims where workers have received benefits beyond 1 calendar year. And in order to manage those claims, a prompt return of injured workers to work that is suitable would be recommended to reduce the wage loss benefits paid out in the claim, thereby reducing the wage loss benefits that are open for indexing. Another strategy would be to challenge the initial entitlement to those wage loss benefits if there is enough evidence to do so. Again, that would reduce the wage loss benefits paid and therefore reduce the liability to indexing. And in relation to chronic mental stress claims, I think the one rule that you are probably doing in your workplaces already, but is especially important in the WSIB context, is to document and investigate harassment allegations as a workplace chronic mental stress claim may be based on that allegation of harassment in the future. And, it would be relevant to have an investigation report and especially discussions with witnesses of what actually took place at the time. Because with chronic mental stress claims, as with all things that touch on the world of psychological injuries, they might not be readily apparent, and you might be dealing with this 2-3 years down the road. Now I'll hand it back over to Allison for some of her tips.
Thanks, Daryl. So I've touched on the first one already, which is make sure your staff are all aware of the changing timelines to file your Form 7s. As we know, we have a lot of usually like plant managers and so on filling out the forms. A lot of people have been doing this for many, many years and will recall that although the Act says 3 days, they've got 7. And so please remind them that is not the case anymore. With regards to communicable illnesses, the big one we would say is you want to review and improve your internal policies and practices for identifying reasonable steps to address any outbreaks, no matter how small, of communicable illnesses in your employment sites. And that might mean looking at your PPE, looking at your sick leave policies, looking at how people are moving around and whether or not there's going to be areas that are high risk and need to be improved upon. You also want to make sure you're taking excellent records because, again, if you get a claim like this, you're going to have to be able to say to the WSIB, no, these are the steps we took. This is what the workplace looks like. And this is why it's unlikely that the communicable illness came from the workplace. And with that, I'm going to turn it over to my colleague, Mike, to talk to you about occupational health and safety.
Great. Thank you, Allison. So just as a reminder, as we get going, what Louise and I are going to try to cover in this remaining time that we have together, we're going to try to take you through the recent trends, charges, the increase in fines, the maximum fines, critical injury trends here in Ontario, Ministry of Labor blitzes of recent and what we think might be coming, some of the enforcement trends. We'll talk a little bit about inspection versus investigation, and that's really important for the purposes of your obligations as you interact with a Ministry of Labor inspector. The impact of the R versus Sudbury case, many of you have heard of that over a lot of discussion over the course of the last couple of months in terms of the potential impact of that case. And then we'll finish with due diligence and practical tips to try to minimize your risks. As everybody knows, the objective of the Health and Safety Act is to motivate all of us to try to take every precaution reasonable in the circumstances. And so if you're looking for sections and you're looking in the Act, you'd look to Section 66 that sets out the culpability if someone contravenes or fails to comply with the Act or the regs, or an order or a requirement of an inspector or the director, and or an order of the minister. And it sets out further sections under Section 66 as it relates to corporations, directors, or officers. And it also talks about aggravating factors that we'll get into a little bit later this morning. As you can see on the slide, if you haven't looked at the maximum fines over the course of the last year, you're going to be quite surprised, we suspect, with the increased maximum fines. The key point for this is these maximum penalties apply to offenses committed after October 26th of 2023. So they don't apply if you have an existing charge or a charge that was laid in relation to an event that occurred before October 26th of 2023. When we look back historically, we see that these fines have, I think it's fair to say, the maximums have tripled or quadrupled since about 2017. It's really sending a message with respect to where the government wants to see our attention as employers with respect to the importance of health and safety initiatives in our workplaces. It also reinforces, we suggest, the importance that directors and officers be apprised of and stay involved in health and safety matters within their organization. Don't simply fully delegate that liability or that responsibility. So you'll see the fines on the slide, and I don't intend to read through them, but I do want to cover off a couple of high notes. Not only are there these monetary fines, and if that wasn't enough to get everybody's attention, remember that the Act also provides the ministry with an ability to seek a prison term of up to 12 months. And we've seen some movement over the last half dozen years where that's actually been on the table, and it's a risk. The other part to note is that 2-year limitation period. If somebody suffered from an accident today, here on March the 6th, it used to be that the ministry and the Crown working together could take until March the 6th of next year to actually lay the charge. Please note that that has now changed. It's now a 2-year limitation period, so they get more time to decide whether or not they're going to charge under the Act or the regs. There's also aggravating factors. I'm going to get into that in a moment, but not to confuse matters. So that's the Occupational Health and Safety Act piece. I want to remind you, if we can, that remember they've also made amendments to the Criminal Code of Canada, specifically Section 217.1. You want to be aware, and that's several years old now, but we're seeing the government use these sections. And really, it's creating a criminal code offense. And what we say from a street language perspective, it's you're susceptible to being charged if somebody determines that there's been a marked departure from the standard of care. That seems to be the phrase that a lot of us use when we're trying to interpret it. This goes all the way back to the Westray mine disaster. Everybody probably has heard of that. If you haven't heard of that, it's worth a bit of a read, because the 217.1 of the Criminal Code of Canada came out of that disaster and a review of what happened in that disaster. And just in short, that disaster was all about a corporation making some decisions that they were found to have made for budgetary purposes that endangered their workers. I'll leave it at that. It's much more complicated than that, but let's go with that for a moment. The most recent case that took a lot of press in Ontario was back quite a while ago, but it ran through the courts for a significant period of time. In 2009, we had a swing stage accident here in Toronto where a number of workers fell to their death. Some survived, some did not. That case, although it started, the accident itself happened in December of 2009, it ran through the courts all the way through to a Court of Appeal decision in 2018. And in that case, the site on that case is R versus Kelna Nelson. It's a 2018 Ontario Court of Appeal case cited as at page 77. A supervisor in that case is found to have knowingly allowed these workers to work on a swing stage where there weren't sufficient lifelines. There were 6 workers and there were only 2 lifelines. And again, much more complex or more detailed than that. But what happened in that case ultimately is the first level court ordered 3.5-year imprisonment terms to the supervisor at the time for 4 counts, and they were concurrent sentences. And that supervisor appealed that sentence, and the Court of Appeal confirmed the lower court's ruling. So it's just flagging for you that we also have criminal code responsibility that we want to be aware of as well. When we get into the aggravating factors, for the last 20 or 30 years, when you appeared in court, if you were convicted of one of the sections of the Occupational Health and Safety Act, and we started to look at sentencing, there was an old case called Cottonfelts from 1982 that became the standard case to look at factors that the court would consider. Cottonfelts said, we want to make sure that the outcome of a conviction has a general deterrence message. We want to look at the size of the company, the economic activity. We want to look at the statute. What's the maximum penalty? Remember, the maximum penalty now for a corporation is up at $2 million. Very significant. And by the way, these are per count. In many accidents, we see multiple counts in the charging after the accident. They want to look at the health and safety record, remorse, and what were the entity's post-remedial actions. Well, now under the aggravating factors, they've actually legislated. Instead of a judge looking at some of these things and following a case, they've said, if somebody's convicted, we want you to look at the following. And there are 10 of them, and I'll touch on them very briefly. The first one is, did the offense result in the death, serious injury, or illness? Was the defendant, so a corporation or a supervisor as an example, were they reckless? Did they disregard an order of an inspector? So had an inspector come to the workplace, ordered some remedial actions, and did we disregard that? Have there been previous convictions? Is there a record of prior non-compliance from an order of an officer as an example? Was there a lack of remorse? Was there moral blameworthiness? Was the action, the causation of the accident, the root cause, was it motivated by a desire to increase revenue or save costs? Back to that Westray case way back. The ninth one was, after the accident, was there an attempt to conceal what happened, and or was there a failure to cooperate? And then with, like all legislation, there's an other section that provides the government the ability to enact further regulation in terms of things to be considered. The last point on this is, please note that asterisk on the slide where we say each offense, if convicted for them, and there's a fine amount, there's a mandatory victim fine surcharge. And we'll talk about that as we go through the cases, but don't lose that 25% mandatory victim surcharge. So if we move from there, the next 3 slides are all about recent cases, and I don't mean to cover them all, but we thought it would be useful for you to have 3 slides of the kind of convictions that have occurred over the course of late 22 and frankly most recently and also in the spring of 23, and they bring home a couple of things for us. I'll just talk about that first one for a moment. This is ultimately a $50,000 fine plus the victim fine surcharge, and as you'll see in this one, it's a worker who's fallen approximately 6 meters into the bottom of an unguarded elevator shaft. You're going to find some commonalities in my comments as I go through. Again, the failure to have sufficient guardrails. Notice that the sections refer to 26.3 sub 1 of Reg 213. So Reg 213 deals with construction workplaces. So when you look at the act, you'll find regulations that are written specifically for different sectors, whether that be construction or health or mining or an industrial setting as an example. I'll leave this slide and go to the next one. And just, I want to pick off that one in the middle because December of 22, you'll see there's a series of fines. So in this one, 2 workers were critically injured from a fall caused by, again, an elevator shaft platform collapse. But look at the fines. The constructor gets a fine of $150,000. The employer gets a fine of $200,000. Supervisor as well at $15,000, and a $15,000 fine for the director, plus the victim fine surcharge. This one's up here just to bring home the idea that in the same accident, there can be multiple parties charged. And the ministry looks for that. It happens quite regularly. In the old days, I'm talking 20 years ago, you could argue with a Crown and horse trade, frankly, a little bit. Our experience recently is the horse trading. In other words, if the supervisor pleads guilty, will you not continue the proceeding as against the employer? Those days feel like they've disappeared, and it's really a message from our government that there are multiple workplace parties, and they want to incent everyone to participate in keeping workers safe. If we go to the next slide, and again, you can read these in the goodness of time. We just wanted to make sure that you had them. So if we keep going, we wanted to give you a bit of a trend look as well. And these are published statistics, and you may not be able to see that little asterisk. We just pulled the construction sector out as an example. You'll see that there has been improvement in critical injuries, but frankly, pretty steady state in the fatalities that we've suffered in that industry here in Ontario. And so that's looking at all of 23 over what happened in 22. We're making progress on critical injuries, but we need to spend a lot more attention on the root causes of fatalities in construction. We move to the next slide. These are some of the blitzes, as some people refer to them, and you'll see we're at the tail end of these blitzes, but we still wanted to cover them. So just briefly, falls from heights, single-family residential homes. So if you think of that, when a worker is putting up trusses or working on the sheaths that go on the trusses, are they tied off? Are they using the appropriate fall restraint? Do they have their fall protection training? Those are the kind of things. And note what the government's doing on these is it's looking at education, outreach, and awareness first. That's a typical trend when an inspector comes to the workplace. So this is a proactive coming to the workplace as opposed to responding to an accident. And they're looking at trying to assist and educate and raise the awareness as opposed to simply issue orders. Orders can occur. They're typically after an inspector's made some of these efforts to begin with. You'll also see they're looking at struck by equipment. So in multiple settings, we've seen that not just in construction, even though that's the focus. We've seen that in multiple different settings where the ministry is quite interested. And then to go through these very quickly, material handling. So that's in industrial facilities. That can be everything from how workers are trained with respect to lifting, to how workers are trained and ticketed with respect to the use of a forklift. Same common theme, focus is education, outreach, and awareness, but it can move to orders. Asbestos in building structures, and then finally, the prevention of musculoskeletal disorders, acronym MSD, in healthcare settings. And that's what, when we're talking about lifting, transferring of patients, and those injuries are typically back injuries, shoulder injuries, and they're going to want to see what kind of procedures do you have in place? What kind of training is conveyed to your workers? And have you documented that? So if you take anything away from the blitzes, think of it this way. An inspector can come to your workplace. Section 54 says they have the authority to enter your workplace. In other words, you can't block or deny them entry. We say if you're involved in any of these blitzes or proactive inspections, I want to keep a detailed record. I want to keep a record of what areas of my facility did they visit, what information did they request of me? And remember, they have very broad request rights. They don't typically ever take away original documents, but they can certainly request the provision of copies. Which employees were interviewed, if any of them. So keep those things in mind. And there's lots you can do when you see blitzes like this occurring. There's lots you can do to prep. And we can help with that prep. We can take you through a dry run of what an inspection might look like in a blitz. And lots of our clients have taken us up on that offer, relatively efficient and quick, but it's almost like, walking through, do we have any gaps in what we should otherwise have here from a paper record, let alone just what an inspector gets to see when they observe. Remember, they can actually go on a machine and test out a machine. And I say in the old days, it's probably happening somewhere, but in the old days, we used to have workers who would disengage the guarding function that would not allow them to get near something dangerous. And an inspector is well within their rights to try and check that if they were in your workplace. If we move to the next slide, here's just a quick snippet. These people are active. They're visiting sites. That first stat, 1,000 field visits. Remember, we have about 500 inspectors that are spread out visiting sites proactively, let alone when a complaint comes in or when there is an accident. You have stop work orders. You have rights under stop work orders, but first and foremost is to comply with that order, then try to remediate. In other words, to follow the directions of the inspector as it relates to what you want to do to have that stop work order lifted, and or you might be off to the Ontario Labor Relations Board if you get into a debate or discussion where you think you've done what you need to do and you're still in a debate with an officer. If we move to the next slide, I know these are really tiny, but I can tell you when you look at the left side where they're the most frequent, these are all involved with falls. It's unfortunate, but falls from height are probably the number one. And if not height, so somebody's working at a level above 3 meters, sometimes it's guardrails around a hole, like one of those first convictions we talked about earlier in the session. But falls from height seem to be still a problem. And we want to pay particular attention to training. And then the process that they're trained is actually applied. They actually find an anchor point that they can hook off to with the fall arrest system that they might be wearing, or guardrails around specific issues that could result in a worker falling, but for the guardrail. We move to the next slide. I'm going to talk just briefly on inspections and then hand it off to my colleague, Louisa. Remember, under Section 54, the inspector has the authority to conduct the inspection. Under Section 56, you slide into warrants as well. So Louisa is going to talk a little bit about your rights as an employer or a supervisor when you're visited by a Ministry of Labor, Immigration Training, Skills and Development inspector. 54 gives them significant rights. And by the way, many of us suggest, and we've got a number of clients who do this, an inspector shows up at your workplace proactively. Think about calling counsel if you're not ready to go. It doesn't delay the inspector, but we may be able to help. In the event that you have an accident and you've taken care of that worker, and if they've had to be transported to the hospital, you've dealt with all of the taking care of the worker, but then you move to how do you get ready for that inspection? And we can certainly help with that. And many clients are well advised to get counsel with respect to the accident investigation. And you can tell I'm moving into investigation because at some point we move from inspection to investigation, and it's important to figure out how you understand that. And it has different obligations as it relates to your rights. So we go one more slide, and then I think I turn it over. So again, inspections are typically trying to determine whether or not the corporation, the directors, the supervisors have actually complied with the act. Again, I've talked about broad powers, which does include compelling somebody to speak to them. So the witness interview, in other words, there's a positive obligation to cooperate during an inspection. And the failure to comply with an order can actually result in a violation, as we started when we were talking under Section 66 of the Act as well. So Louisa is now going to jump in and start to say, oh, here's where the rights change. And it's a bit of a setup because it's not that easy sometimes to figure out where that line is. So without further ado, Louisa, floor is yours.
Thank you, Mike. So as Mike mentioned, there is a point or a natural transition at a certain point where an inspection becomes an investigation. And we're going to take a look in a moment as to when that actually occurs and when that transition happens. But before we get there, we want to ask first, why does it matter? there are certain protections that become available for individuals and corporations once an investigation has commenced. And we're looking at it from the perspective of the Charter and the Charter of Rights and Freedoms specifically. So we're looking at sections 8 and sections 10b. Section 8 talks about the right to be free from unreasonable search and seizure, which is a right that a corporation has. And section 10b talks about the right to counsel. So the idea is if an individual has the potential to be charged under the Occupational Health and Safety Act, we're looking at offenses that are quasi-criminal in nature, right? And so for that reason, there's greater liability at risk for the individual. So when we're thinking about, you know, your supervisor, director, or your officer under the, pardon me, your supervisor or director under the Act, you're thinking about individuals. And so therefore you're thinking about the right to remain silent so as to not incriminate yourself. But you know, to the earlier question of when does that transition actually happen? Fortunately, there's not really a clear-cut line. There's no magic line, to put it in the words of the Supreme Court of Canada, as to when that transition actually occurs and when an inspection becomes an investigation. And so for that reason, employers are often put in a very challenging situation where they're faced with the tension of being risked to be seen to obstruct an inspection versus that risk of potentially offering more information than is necessary and self-incriminating themselves. And so for that reason, the best clarity that we really have is the question of at what point are there reasonable and probable grounds that, you know, there are going to be charges laid. That is the closest that we get in terms of what that line actually looks like. But again, it's very difficult to discern in practice. Practically speaking, I think we look to inspectors to exercise those kinds of rights and powers responsibly. Inspectors will often caution a witness when they are starting to suspect that they're going to move to lay charges. And that's when we kind of see that inspection become an investigation. So for example, an inspector will say, you know, you don't need to cooperate with this, or I don't need to get this information from you. Don't volunteer it if you don't want to, or something along those lines. That will often start to sound like you're moving from inspection to investigation. Another telltale sign is a search warrant. Typically, if inspectors show up with a search warrant, that's starting to look like there are reasonable grounds to believe that there's going to be a conviction that'll be secured. So these are the kinds of things that practically on the ground we can help you try to navigate. It is very much gray area. It's very challenging to figure that out. In one case that I can think of right now, there was actually a supervisor that didn't want to participate with a Ministry of Labor investigation. She was called in to actually provide a statement at their offices, and she refused to. There was an understanding that, you know, she'd be obstructing their investigation if she didn't comply. So ultimately, at the end, the court took a look at all of this and decided to exclude that evidence on the basis that by that point, when the supervisor had been called in to provide the statement, there were reasonable grounds that charges would have been laid at that point. So things can sometimes be done after the fact, but it's very important to kind of navigate these things slowly. And in particular, consider calling counsel when and if a critical injury occurs in the workplace. We certainly hope it's never the case that they do, but the reality is that at some point it will. It's really important to consult with counsel, seek their guidance on, you know, how to navigate the actual process, the inspection, if it transitions to an investigation, the kind of information that's being collected, where there's a requirement to comply, or where there's a requirement, for example, to have counsel present in order to prevent the risk of self-incrimination. Because these things can be so difficult to navigate, we have a really helpful resource that we've put together as a firm for you. It's the SK's 12-step accident checklist. There's going to be a copy reproduced in the slides at the end of our presentation today that sets out what those 12 steps are, but we actually have hard copies laminated of this checklist as well. There's going to be an opportunity, and I'll remind you again at the end of the presentation, we're going to prompt you at the end for some feedback, and we'd really appreciate your feedback if you have a chance. In your feedback, please feel free to leave us a note indicating that you're looking for a copy of that checklist, and we'd be happy to follow up with that. So let's get into RV Sudbury, because I know that this is a decision that's really caused a lot of stir and a lot of commotion for a lot of individuals, particularly stakeholders, municipalities, and in construction settings. But I think this decision has larger implications for who might be considered an employer as a whole. So at the tail end of last year, we saw a lot of turbulence, right? You would have heard Mike speak about the increases to the maximum fine amounts in the legislation as a result of Bill 79. In tandem with that change, we saw the decision of RV Sudbury released, I believe it was November of last year. And RV Sudbury really kind of changed the map, I think, for a lot of employers in terms of, when am I going to be considered an employer for the purposes of the Occupational Health and Safety Act? And what does this mean in terms of liability going forward? Before we unpack the decision and we take a look at what actually happened, we think it's useful and helpful to you to set out a bit of foundation about the Occupational Health and Safety Act to really appreciate kind of the nuanced changes that this decision has caused and created for us. So we're going to take a look first. What you'll see on the slide there is Part 3, Table of Contents, Part 3 of the Occupational Health and Safety Act, which may be familiar to some of you. In particular, the three kind of entities that we're looking at, or three parties that we're looking at in this decision, are constructors, employers, and owners. And each of those entities has a definition under the Occupational Health and Safety Act for when you may be found to be, for example, a constructor. And I believe I saw a question about that earlier. So that's luckily we're going to address that now. And by proxy, the reason why we care is because if you are found to be a constructor or an employer, you're going to have corresponding obligations and consequently liability as a result of a failure to meet those obligations under the Act. So let's take a look first at the definition of employer. So the definition of employer is a person who employs one or more workers or who contracts for the services of one or more workers. In the 90s, in a decision called RV Wyson, the Court of Appeal for Ontario looked at this definition and was very clear that because the idea of occupational health and safety legislation is to ensure at all times, the health and safety of employees and members of the public who might be in work sites, there's really not that opportunity for an individual to try to carve out liability or try to carve out of their obligations as an employer for the purposes of the Act. So in that particular case, we were looking at an independent contractor relationship as opposed to the traditional employer-employee relationship. And the court was very clear that even contracting for services and having an individual work as an independent contractor and be in business for themselves does not mean that you are somehow contracting out of liability for the purposes of the Occupational Health and Safety Act. And I mention that now because RV Wyson is also a decision that's cited and considered in the analysis of the Supreme Court later on. The other definition that we're going to look at is the definition of a constructor. A constructor means a person who undertakes a project for an owner and includes an owner who undertakes all or part of a project by himself or by more than one employer. In a nutshell, constructor, typically we see that being applied to, think of your general contractor on a construction site. The general contractor will either choose to delegate. So for example, they'll be retained to delegate, all of the ways in which the various work on that construction site is performed, perhaps outsourcing it, subcontracting it to trades and other various entities. In some cases, the constructor will retain a portion of the work that's to be performed on the site for itself. So it may choose to act as both a constructor and an employer on the site. And lastly, we have the definition of an owner, which is a bit more straightforward. It includes a trustee, tenant, leasee, other similar kinds of similar types of titles, or an occupier of any lands or premises used as or to be used as a workplace. Now, importantly in the legislation, there is a carve out under Section 1 sub 3, which sets out that an owner will not become a constructor by virtue of engaging the services of kind of various professionals, including, for example, engineers or architects. So I like to kind of call this in a nutshell, quality control. So if I, as an owner of a construction site, choose to engage individuals to do quality control on that site, despite the fact that I've retained a constructor to do the actual work, I'm not going to be somehow found a constructor by virtue of engaging in that kind of quality control analysis. So with that background, let's turn to what actually happened in this decision. So in the summer of 2015, the city of Sudbury, the municipality, contracted with a constructor, Interpaving Limited, to repair a water main and repave streets. So essentially, it created a construction site or construction project. And the city of Sudbury as a municipality has a legal obligation to ensure that any highways, any roads within its jurisdiction are maintained in a good or reasonable state of repair. And that's just important context when we think about really any municipalities that are engaged in that kind of work. But ultimately, again, the city of Sudbury chose, simply to outsource the work to a constructor, and Interpaving, as was its right to do, retained a portion of that work to itself to repave the streets and delegated the other portions of work to other trades. So Interpaving was the GC, it provided its own employees to perform the work, but importantly, and this is the fact that leads to so much trouble, the city employed 2 quality control inspectors to inspect the project. So it had 2 employees on site that would report back to the city of Sudbury, to ensure that things were being kept up to speed in terms of the project, reporting on its status, and importantly, ensuring that the quality was right in accordance with its legal obligations. The other piece to give you some important context on this is that the project took place in an area where it was adjacent to public access. So the perimeter of the construction site backed onto areas like public walkways. So what ended up happening was, quite tragically, in the fall of 2015, a member of the public was crossing the street at an intersection when an Interpaving employee was operating a road grader in reverse and unfortunately, tragically, fatally killed the pedestrian. The Ministry of Labor attended on site, conducted an investigation, and in the course of their investigation, they uncovered multiple breaches of the Occupational Health and Safety Act and its regulations. So specifically, in this case, we were looking at Regulation 21391, which is the construction regulation. And the ministry found that there was no fence of 1.8 meters, as is required under the regulation, to separate the construction project from an area of public access like the walkway. That was one breach. And the second breach was, typically whenever a machinery is being operated on these kinds of construction sites, there's this general requirement that it should be operated in reverse as little as possible, and essentially if it's only necessary. And even if it does become necessary, it's important to have safeguards in place. So for example, a signaler that would be monitoring the way in which the machinery was being reversed, particularly if the view is obstructed or if there's a potential of harm to a member of the public. Ultimately, the investigation resulted in charges for Interpaving and the city, both as employers under the Occupational Health and Safety Act. The city was also charged as a constructor. So what happens at the trial level? The city concedes that it's an owner, has no problem saying, yes, we own this project site. And it concedes the fact that it sent its employees for quality control at the site. However, the city disputed that it was an employer, because it wasn't in control ultimately at the end of the day of how Interpaving workers were performing the work. Importantly, in that analysis as well, the court notes that because of that Section 1.3 exemption, there wasn't a charge established under the constructor portion of the act, because again, it sent its individuals for quality control, and the owner doesn't become a constructor by virtue of doing that. However, the key question was whether or not it was an employer. The trial judge agreed with the city and said that because it's not in control of the way in which Interpaving workers were performing the work, it couldn't be found an employer for the purposes of the act. This goes up to the divisional court, where a similar outcome is reached. Ultimately, the Ministry of Labor appeals that decision to the Court of Appeal for Ontario, and the Court of Appeal for Ontario overturns the decision. The Court of Appeal says, On a very strict reading of the Occupational Health and Safety Act, the city met the definition of employer because it employed 2 individuals, those quality control workers, on the job site. And so for that reason, it meets the definition. And importantly, the Section 1 sub 3 exemption doesn't apply the way that it does in that the owner-constructor relationship. There isn't a similar type of exception that exists when it comes to an owner being found an employer. It goes up to the Supreme Court of Canada on further appeal. Although 9 justices hear the decision, which is helpful because then we'll end up kind of one way or another with an outcome. By the time it makes its way to a written decision, we only have 8 justices. And that's due to kind of personal circumstances of one judge who was not on the bench at the time and removed. So we end up with a split decision where, you know, half of the justices say, yes, the city is an employer for the purposes of the act. And that goes back to the idea of major comments that you've heard from Mike and I both today, right? This idea that occupational health and safety is the responsibility of everyone in any workplace, construction site or not. Right? And this idea that we shouldn't be able to contract out of liability under the Occupational Health and Safety Act. This is what they refer to as the belt and braces approach. And the level of control isn't relevant to the finding of whether or not someone is an employer for the purposes of the Act, although they leave open the door to this idea that although it can't avoid a charge as an employer, it might still be relevant to the defense of due diligence in that I did everything I could, given that I wasn't immediately overseeing these employees in those circumstances to try to avoid this kind of accident from happening. The alternate decision that we have from the remaining justices is that the city isn't an employer of interpaving employees because the definition of employer couldn't possibly have intended to cover a situation where a project owner retains another party like the GC to undertake the project. It would be, to quote, absurd to require an owner to be responsible for workers hired by a constructor where they have no control over those workers. So what are we left with at the end of all of this? We're left with this understanding that, you know, due diligence is still a defense that's available if you are charged as an employer under the Act. I think the logical question that many ask is, well, it seems like by taking steps to try to prevent something from happening at a job site, including hiring individuals to attend at the site, I'm more likely to meet the strict definition under the Act of being found an employer. And although that's true, and although it creates a bit of a catch-22, we say that, you know, where there is that potential of being found an employer, it's better to err on the side of caution and to take steps at the outset to try to avoid the accident from happening in the first place, but also to ensure that you are able to later demonstrate that you did everything you could in the circumstances, given your requisite level of control over the way work was being performed, to try to prevent the accident. A couple of pieces just quickly to note about the decision before we move forward. There was a motion to rehear the decision, given that ultimately we only had 8 justices as opposed to 9. Unfortunately, the Supreme Court of Canada refused to rehear it, meaning that we're left with a bit of confusion as it comes to, you know, the decision across Canada and the state of the law across Canada as a whole. However, the Court of Appeal for Ontario decision still stands in Ontario, which means that our bottom line is, as the owner of a construction site or the owner of a project, you could still potentially be found an employer for the purposes of the Act. The separate question of due diligence, during the trial level, the Crown had argued that the city of Sudbury had failed to meet the due diligence threshold because it didn't specifically take steps to prevent that specific incident from happening. And there was a question of whether or not general versus specific acts are sufficient to meet the due diligence threshold. That's actually been remitted back to the lower court. So we're expecting a decision at some point on that issue, and we'll be continuing to monitor that and update you in due course. But in terms of, for now, what we can do with what we have and what is available to us as the state of the law, we want to think about due diligence and taking steps going forward to try to prevent these things from happening, because there are many steps that you can take proactively. I think fundamentally you want to consider, if you're a stakeholder who could be found an employer, awareness is the starting point. Awareness and education and training under the Occupational Health and Safety Act and its regulations. Review your workplace day to day. If you're creating a workplace like a project site, think about the risks, conduct a risk and hazard assessment. Think about the ways in which perhaps the machinery being used could present a hazard, or the nature of the workplace and environment could create a hazard. Take measures based on those risks and hazards to think through how are workers going to be trained to identify them. How are you going to track compliance with the regulations and the acts? How are you going to seek this information? If you're hiring other individuals to attend at the workplace to perform that work, what measures have you taken at the outset before contracting with them? Have you screened them to make sure that they're using, for example, a health and safety management system? Are they ISO certified? Are they core certified? These are all questions you can ask yourself at the outset to try to ensure that there are measures being kind of looked after or taken care of, even if you are not personally attending at the workplace day to day. And then think through what you're going to do if there is non-compliance. How is it going to be addressed? Will it be reported back to you if you have other entities on site performing the work? Will you be attending personally to try to monitor those things? And make sure that any actions or steps you take with respect to health and safety, that they're taken promptly and without delay. At the end of the day, we want you to remember that safety is a priority. Making safety a key performance indicator for yourselves as a corporation and for the corporations that you choose to work with is going to prevent accidents on site. Champion that, and to the extent possible, ensure that everyone is honoring that. Don't be afraid to allocate sufficient resources to that, and wherever feasible, implement temporary measures as workarounds to ensure that safety is being honored. And you would have heard it, multiple times, I think hinted at, documentation is key when it comes to a due diligence threshold or assessment in the future, or really when it comes to the implementation of any health and safety system. Being sure to document all the steps that you're taking can be essential in helping you down the line. And, you heard Mike mention today the 2-year limitation period. It's amazing how many documents go missing when charges get laid a day before the 2-year limitation period is up. So make sure that you have efficient record-keeping practices in place as well, and ensure that you're taking steps to discipline employees who aren't following their health and safety measures where appropriate. We can assist with all of that. We're happy to help you with that. This is the 12-step accident checklist that we mentioned earlier in today's presentation. And so, that's available for you in the presentation, a copy of which will be provided in due course. But feel free to reach out to us for a hard copy. So with that, we're going to take a look at some questions that have been trickling in during our presentation, and I'm going to send it back over to Allison and Daryl, who can get us started.
Great, thank you, Louisa. I think we'll just split up the questions. I have a few questions here that I'll answer. The first question is with regards to the time frame around super indexing. So basically, when would the super indexing kick in once the legislation has passed? The short answer is the draft allows the government the discretion to choose a date. However, typically indexing happens to January 1st. So remember, the folks that are qualified for indexing will be receiving wage loss benefits in December and transitioning over to January. January is when the indexing applies for that year. So that's what we could say right now. I just checked the status. The status actually has been updated. So this is breaking news at the webinar, and it has passed through standing committee with no amendments, and it's being debated at third reading. The debate has been adjourned, so it's inching closer to being passed. The other question I had was with regards to the time limits around a worker filing for a chronic mental stress injury. Now, this is a bit more interesting. Workers have up to 6 months from the date they know or ought to have known that they've suffered a workplace injury. With things like psychological injuries, that can be a bit murky as folks don't actually, typically in the normal course don't seek psychological counseling right away after an event occurs, or may not even know that they're suffering from a psychological injury until they actually receive a diagnosis. And typically with psychological injuries, that is when the clock will start to run, is the diagnosis of the injury. From an employer perspective, we would have no knowledge of that or control of that. That's why it's very important to document all steps taken to investigate instances of workplace harassment, because what I've seen is 2 years down the road, when the HR manager has changed and, we have some vague recollection of some sort of a harassing event happening, that's when we get the WSIB calling saying, hey, where's your Form 7 for this psychological injury? And the other question I had was, if you receive a medical note and that puts the worker off on stress leave, do you need to file a Form 7? And the short answer is no, unless the worker specifically states it's because of a workplace or alleged substantial workplace stressor. There has to have that work-related nexus. Typically, it might trigger the duty to inquire if we know that there has been difficulties in the workplace and that sort of thing. But in the main, if we just have a doctor's note that doesn't specifically reference the workplace, the duty to report is not triggered. Also, if we do get a Form 8, which is the doctor's report of injury and illness, which sometimes we see that, then as soon as we receive the Form 8, that's when our Form 7 reporting obligations kick in.
I'm actually going to pick up on that issue of Form 7s, because I can see that between 7 and 10 people have asked the same question, which is obviously on everyone's mind, which is, do I file a Form 7 every time somebody says, hey, I've got COVID? And the answer is, do not do that. Please do not file a Form 7 every time somebody tells you they've got COVID. What happens is that the individual still has to meet the test for when you're filing a Form 7. And you might recall, I mentioned it pretty briefly, but it's generally required when there's a work-related accident and the employee has received healthcare or one of those other things I mentioned, such as they're absent from regular work, so on and so forth. So generally with a COVID-19 case, unless there is good reason to believe it is from the workplace, no Form 7 obligation. You'll also recall I mentioned that the WCB has specifically said that simply being exposed to a lot of people doesn't mean it's probably workplace-based when it comes to COVID-19 and influenza. So keep that in mind. Apologies. Keep that in mind. And if you have a situation like that and you've got a question, maybe call us. You don't just want to be filing Form 7s all the time on the basis of COVID-19 especially. One of the other questions that I saw come up a little bit is the Form 7 timing. How does this work if one of the things that causes a Form 7 is that the individual requires modified work at regular pay for more than 7 calendar days following the accident? So what happens, and it's a great question, is that the 3 days starts after the 7 days finish. So if the worker is injured and seeks healthcare, you have a reporting obligation that may begin immediately. So the 3 days clock starts ticking. However, if the worker is injured and returns to modified work at regular pay without seeking healthcare, the reporting obligation doesn't generally begin until the 8th calendar day. So that's when the 3 days starts ticking, because the WSIB has said you have to have those 7 calendar days of modified work. And that's when your reporting obligation begins. And you have 3 days after that. Why don't we turn to some OSHA questions before we keep going on the WCB?
Great. Maybe I can jump in. I'll hit a couple of them. First and foremost, before the slides are posted on the website, we'll update them to have citations of the cases that we referred to. So no worry on those citations. We'll get those out. So you have them on the slides that you can access. There was a question about the 2-year limitation period, and let me just review briefly. Let's assume there was an accident today, March the 6th of 2024. What's happened is the Ministry and the Crowns now have 2 years from today's date to actually lay the charges. Our experience is they don't get anywhere near that tail end, but we have seen charges in past years where it was 11 months in. So it won't surprise us if there are charges 23 months after an accident. And so you heard my colleagues comment, Louisa, really, really important when you have those inspections and orders and or the investigations, that you do your own investigation, and hopefully you put it in a box and it's tied up neat and tight and we never have to look at it again. But if 23 months from now we get charges that you're going to have to defend with hopefully some good due diligence, you'll be well in place if you followed Louisa's comment earlier about do your investigation now, plug all of those pieces that you need to have in place so that when you go to court, you can show that you were duly diligent to try to afford yourself a good defense against those charges.
Maybe I can jump in next. So I saw a question in the Q&A asking whether or not you can record a Ministry of Labor investigation. It's a good question. What I will say is, formally, I don't think inspectors are going to be very comfortable with the idea that they are being recorded. That being said, when you are having the Ministry of Labor attend on site, it's certainly within your rights to reach out to council. If we attend on site, you can request that we be present during the Ministry of Labor inspection and or investigation, depending on what stage that's at. It's within the ministry's rights to refuse. They can decide that we shouldn't participate, but there's no harm in asking. In any event, what's helpful about having us engaged is that we can then speak to any witnesses that the Ministry of Labor would have interviewed to essentially try to recreate what questions they would have been asked. There's absolutely no harm in doing that. In fact, it's quite helpful, especially if we get into a situation later on down the line about whether or not there would have been reasonable grounds at a certain point to have a conviction. So I think these are the kinds of things that we want to think about and be mindful of in terms of what we can record. There's another question as well that I saw, and maybe I'll pass it over to Mike right after. There's a question from someone who was asking about, so their office has moved to a new location and there's construction underway at that location. Is there a likelihood of an inspector visit? And the question was, can we consult a lawyer or a third-party inspector to help us understand if we need to follow any steps we may be currently missing? So I think you heard a little bit earlier, Mike was mentioning some of the blitzes that are going on. The Ministry of Labor, in terms of kind of having attendance on site or at work sites, they may do so proactively as part and parcel of a blitz. That might be one of the reasons why they'll attend on site. The other more likely reason is that there's actually been a critical injury in the workplace which has been reported or has either come out, for instance, from a 911 call. Those are the usual circumstances where the Ministry of Labor will attend. They're not usually going to attend just by virtue of kind of a new construction project being built, unless there's certainly that possibility, but there's no requirement for them to do that. In terms of the second portion of the question, it's absolutely within your rights to consult a lawyer or health and safety consultants to do a gap analysis to see if there's anything currently in the construction project that isn't in par or isn't in compliance with the regulations under the Occupational Health and Safety Act. And I'll turn it back over to Mike to see if there were any other questions he wanted to touch on, and then maybe we could do another round.
Maybe I can just a couple of quick ones, and then we'll go back to WSIB as well. There was a question in the series of questions we're looking at right now. One of them was, if I'm in a setting where, for example, a retirement home or a nursing home, where some of the work is actually going on in an occupant's unit, as an example, what do we do when a Ministry of Labor inspector wants to enter into that? And I'd refer everybody to take a look at section, I think it's 55 of the Act, because it's very specific to the inspector's ability to enter into a dwelling. And at least on that section, it would suggest that the inspector needs the consent of the occupier and or if they have a warrant. So there's a couple of different ways they can handle it, but they're typically our experience has been they're sensitive to that. 9 times out of 10, they're going to cooperate. Back to the recording piece is really difficult sometimes, and we've had the following experience. An inspector says no, and they want to continue on, or Louise and I have both had that experience, and I'm being a bit repetitive of her comments, but there's also the situation where you do call counsel gets in, we actually start to do our own interviews because we're going to investigate as well. And then when we wish to participate in an interview with a witness and the inspector says no, and they're not prepared to. And again, those are situations where we want to be very careful not to obstruct, but we also want to be careful to do our own investigation. And there are a number of ways of doing it. So I think if we had to go one way or the other, if the inspector said, I'm not prepared to allow you to record, I want to continue my inspection or my investigation, I think we're probably in a situation where we want to allow them to do so that we are not seen to obstruct. But what we'll do a lot is the minute that investigator is finished with a witness who they've interviewed without us, there is nothing wrong with one of us interviewing that witness as well. So we get contemporary, like timely notes so that we've got a pretty good investigation. Make sure we do it. And remember, you may be doing it with your joint health and safety committee reps as well. So there are some other obligations that we've not covered today on the joint health and safety side. But recordings, if they force it, I wouldn't push it personally from an advice perspective. And if they don't want counsel in the meeting, again, being repetitive, I wouldn't push that as well. But I would do my homework both before those interviews and after those interviews. So I've really, hopefully, collected the investigation I'm going to need to run a defense if we're required to do so.
So we are mindful of the time, and this will probably bring us to the end of today's program. We do hope you found it informative. The video and slide deck is going to be available on our website for those of you who have asked in about a day or so. And we know there were a number of questions today. If we didn't get a chance to answer your question, please don't hesitate to drop us a line. We'd be happy to take this offline and to discuss it with you. Our next HR review webinar will take place on June 5th, 2024. The topic is in the design phase, and we'll send out an invitation in due course. If you're on our mailing list, you'll receive an invitation. And if you're not yet on our mailing list and wish to receive our briefing notes, newsletters, and invitations to seminars and workshops, they're very helpful, please subscribe through our website. It's the big red bar at the bottom of every page. Finally, we'd be very grateful if you'd fill in the feedback form that will pop up on your screen once we close this Zoom webinar. Just a reminder again to please leave us a note in your feedback about whether or not you're looking for that 12-step checklist, and we'll follow up with you afterwards with a hard copy. Thank you again for joining us, and we hope you have a great day.